Hello everyone, this is Samsung X from the School of Intellectual Property in the East China University of Political Science and Law. Today, our topic is patents. This is the first part of my lecture on patent law in China from a comparative perspective. This lecture is composed of 4 sessions. Session 1 will give you a brief history of patents. From this session, you will see patents, however, existed before the law, which means before the creation of modern patents legal system. Patents already existed. Why and how could it be possible? What are patents before the birth of a modern patents legal system? In this session, we will have a very quick look at the historical development of the modern patent system and how it was introduced into China, and what's the current legislation concerning patents in China today. Session 2 will talk about what things can be patented under patent law. This is called patent subject matter issues, with the scope of patentable subject matter. Not anything discovered or invented by mankind can be patented. There are limitations. There's a scope. Section 3 is about the test called patentability. Patentability is about the legal requirements for granting of a patent. This is the most fundamental principles under patent law. This part would be very important for you to understand the entire patent system. Section 4 is about the patent application proceedings and post-granting proceedings. Patent granted upon application. However, it can be invalidated or revoked. You will understand patent law is carefully trying to strike a balance between competing interests, the interest of inventors, the interest of the public for the dissemination of knowledge, and the interest of individual users of the patented technologies. Through those procedural arrangements, you will see how carefully the patents legal system creators are trying to strike. Section 1 A Brief History of Patents. After taking this session, you may see the classical starting points in the development of a modern patent law was a reaction against the unrestricted grant of patent monopolies. And after taking a look at the history of a patent system, and you may come up with your own conclusion how the patent system, the modern patent system, were created and why. It is generally considered that the history of patents and patent law has started in Italy in 1474, which was issued by the Republic of Venice. They issued a decree by which new and inventive devices, once they being put into practice, had to be communicated to the public in order to obtain legal protection against the potential infringers. At that time, the period of protection was 10 years. You will see The very original creation of a patent system still exists today. The core structure, the basic principles, and the purpose of a patent system still lasted until today. From the very interesting case of Galileo's invention, the patent story around his invention was quite a good example for you to understand the patent system today. As we discussed in our last lecture, this decree issued by the local council, the local authority of the city where Galileo lived at that time. It tells you clearly the scope of patented subject matter. That was an invention by Galileo, a device which may raise water by means of one hose. And it also tells you what's the exclusive rights granted to the inventor Galileo. The exclusive rights granted to Galileo would enable Galileo to give permission to those who's looking for license to use his technology. Those rights include the rights to make, have made, or if made elsewhere, to use a device invented by him. From this decree, you will also see the most important part following the granting of exclusive rights as the disclosure of the details of Galileo's invention. The disclosure of Galileo's invention, of course, is much more than what we have here in these slides. It could be 2, 3, 5 pages. There could be drawings included in the pages, which will enable anyone who had these documents in hand will know how to implement this invention to produce this device and operate it. You may say the original idea of granting Galileo such a patent is that the state tried to encourage a person like Galileo to disclose his or her invention, new knowledge to mankind, to the public, so the entire mankind may benefit from these brilliant ideas. How can the system encourage inventors like Galileo to disclose his invention if these inventors were not going to give away for free their inventions? Because the invention is not for free, it's not possible if you don't have significant investments of resources, human resources, and monetary resources. So when Galileo asked for rewards for his invention, the local authority or the king or the queen, the monarch in that state, or the governments would confront it two questions. Number one, this inventor is looking for something rewarding them for the invention. How much should this inventor be rewarded? Right? How much your invention is worth? Should we pay you $1,000, $2,000, or $200? How much should the state pay you? The price of the invention, the amount of the rewards. No one knows. Number two, who is going to pay him? There could be hundreds, thousands of inventors, tens of thousands of brilliant ideas. Who knows which one would be so important, would be more important than others? There could be significant economic burdens on the state if the state is going to pay him or her. So the patent system perfectly solved the two problems, giving clear answers to the two questions raised before. Number one, how much should we pay you? Should the state pay you, the individual inventors? Well, the patent system create a, a mechanism or enable the inventors to charge fees for the use of his or her invention. So the price they can charge based on the potential markets of his or her inventions. So the market will decide how much should the inventor be rewarded. To the second question, who should pay the inventors? Individual users of the patent technologies, the licensee of the patented technologies, and those who sell the products and make the product and sell the products on the markets to the end users. So the end users, by paying the price of each pieces of the products they bought from the markets, indirectly, they also pay for the use of the patented technology. So the price of a mobile phone, the price of your laptop, of course, is composed of many different parts of cost, which includes a high portion of the cost will be the patent fees or patent royalties paid to patent owners. You see, individual consumers, you and me, will only pay you the inventors a very small amount of money to have the best technology. You see, the modern patent system is a very carefully tailored system, accommodating the interests of each party. That's why I call it a win-win-win system. Everyone is a winner. Also, the patent system encourages the disclosure of new knowledge. Well, there is one of the benefits is that considering the cost of research today, research R&D, research and development today, to solve this technical difficulty, technical problem, a company like Lenovo, Intel could invest millions, tens of millions, even billions of dollars in looking for solutions. If there were no such a system like a patent, many companies, many inventors, scientists would be working on the same issues. The company in China invests tens of millions of dollars. The company in the US, the company in Japan will all spend a lot on the same issue, the same problem, but at the waste of resources, human resources, monetary resources. With the modern patent system, today, any company which is setting up a new research and development project, they definitely would have to check the database of patents to see whether the problem has been solved or not. If it's been solved and patented, and then it will be pointless to invest significant money into the same issue, right? So that is one of its most important advantages and benefits of the modern patent system. You see, the original concept of patent law is quite ideal. It's convincing to you, at least for this moment, right? And to inventors, to those companies which are operating or those companies own lots of patented technologies. The patents, of course, will create a significant market advantage to the business. So patents, of course, is a beautiful asset to those companies, to the inventors. You may understand now, from the year of 1474 to the year of 1594, when Galileo was granted a patent, the practice of granting patents by local authorities by means of issuing a decree granting monopolist rights to individual inventors existed for over 100 years. This all happened in continental European countries, Italy, Germany, France. However, in England, at that time, the technology and economic developments, social developments in England was much less developed than those in European continental countries, of course. So people in England realized that the advantages of such a patent system, granting monopoly to individuals, encouraging them to introduce new technology from the continents to England, the island. The monarch, the king or the queen, the UK governments at that time, they borrowed this concept and also issued many decrees to grant patents to inventors and those who introduce new technologies which might be invented in European continental countries and introduce it into England. So to encourage the idea of taking foreign technologies and implement this technology in England, that would be beneficial, of course, to the development of technology and the making of better products in England. So in England, the idea of granting patents was not just to encourage original novel inventions, but also to encourage the popularity of new technology which could be invented in another country. So this was implemented by the practice of later patents. Those later patents issued by the monarch to grant monopolies over particular industries to skilled individuals with new technologies. This, as we mentioned earlier, those new technologies might not be invented by this individual. It could be first introduced into England for the first time. This idea of granting monopolist power to individual companies or firms or industries were highly abused by the following monarchs. For instance, by the King Elizabeth I. Queen Elizabeth I was the most well-known abuser of the letter patent system. She issued many letter patents, not for inventions, but for common commodities, staple articles, the common goods or products, such as starch and salt. Can you imagine what does that mean? It means across England, there could be only one seller of salt. And what would be the consequences? Of course, due to monopoly, only one seller. The price charged by seller will be unbelievably, unacceptably high. So this caused significant problems to the people at this time. So the entire society suffered a lot from the abuse of the letter patent system. From the beginning to the middle of the 17th century, capitalism gradually taking place replaced the feudalism. So the market were allowed to play a key role, and the capitalism and market economy created a new class. And the middle class, they have the motivation to abolish the existing crown powers. So in both European countries and England, the powers of the crown, the monarch, were gradually limited or even abolished. So in England, the crown power, as you may all understand, was significantly reduced to a very limited scope. So by the time of the middle of 17th century, or the beginning of 17th century, the UK Parliament gradually earned the power to make laws. So the king or the queen lost his or her control over the parliament and the power to make laws. By the year of 1623, the UK Parliament passed a new law, which was the Statute of a Monopoly. This is a very, very important legislation. This is a landmark case. This is believed to be the birth of modern patent system, the birth of a modern patent law. Remember, over 100 years of practice granting patents, letter patents to individual inventors or individual industry skilled people or skilled individuals or individuals with special skills. That practice was merely by issuing decree by the local authority or by the queen or the king at that time. There was no such a thing called patent law. However, after the Statute of Monopolies 1623, they have a law called patent law or a legal system which was very similar to the modern patent legislations. Why the statutes of monopolies? You see, the title of these statutes is called the statutes of monopolies. It's about the monopolies, right? However, it's not about monopoly itself. It is not to support monopolies. It is a statute against monopolies. So these statutes repealed, abolished all past and future patents and monopolies, which were issued by the crown, by the monarch. But these statutes make one exception. It says no patents anymore, except those created in the future over completely novel inventions. So this exception is considered as the beginning of a modern patent system. Of course, that was just the beginning of a modern patent legislation. After the Statutes of Monopolies 1623, it took over hundreds of years for the evolution of modern patent system. Today, the patent law we have in China, in the UK, in the United States, in any other countries, are the results of many, many years, centuries of innovation or evolution. In China, as we mentioned in our last lecture, to stop the falling of the Qing dynasty, those scholars visited many Western countries and come back with the idea of a modern patent system. They argue that by supporting Mr. Science and technology, the China could be much stronger. So Mr. Science and Mr. Democracy were the savior of China. So without notable debates, the modern patent system was introduced into Chinese legislation. The first patent-specific law in China was enacted in 1889, toward the end of the Qing dynasty. This legislation were officially passed by the Qing dynasty. However, it was not actually implemented because the Qing dynasty did not manage to survive. However, the concept of patent protection was widely accepted at that time. However, after the end of the Qing dynasty, there were many, many years of war in China until the birth of Kuomintang governments. There were no patent law created, but the Kuomintang governments established a quite comprehensive system of civil law, including intellectual property law, patent law, and trademark law. The legal system implemented by Kuomintang governments were completely abolished by the new China in 1949. So after 1949, until the Cultural Revolution and the open adult policy was implemented in the end of 1970s, there were no intellectual property legislations at all. The modern IP system in today's China, as we discussed earlier in our last lecture, started from the year after the open adult policy were implemented, after the market economy were introduced into China, which was around 1980s. So the Patent Law of China was made in 1984. 1 year later, China became a member country of the Paris Convention for the Protection of Industrial Property. Paris Convention covers the protection of industrial property, which refers to patents and trademark. Then in 1992, the Patent Law of China was amended again for the first time. And 2 years later, China became a member to the Patent Cooperation Treaty, PCT. The PCT system is a system to facilitate patent application in different countries. It's an international patent application mechanism. However, you must keep this in mind. Even with the PCT treaty, until today, there's no such a thing called international patents. The PCT system is merely a mechanism to facilitate the application and examination of patents in different countries nominated by individual inventors. We might be back to this topic later. And then in 2001, when China was in an effort to bring her legal system in line with the relevant provisions of the TRIPS agreements, the Patent Law of China was significantly, comprehensively amended for the second time. As around that year, around 2001, the Patent Law of China, Trademark Law of China, Copyright Law of China, and along with many other civil laws, were all significantly amended and updated. In recent years, in response to the internal needs of creative economy, China amended her IP laws in recent 5 to 7 years. For instance, patent law was amended for the third time in 2008, and trademark law was amended in 2013, and the third amendment of copyright law is now on its way. So the National People's Congress just last month has made a new draft for the amendments of Chinese copyright law for the public to comment. So it's highly possible that the third amendment of China's copyright law could be issued in this year. Meanwhile, the Patent Law of China is to be amended for the fourth time, and the amendments has been proposed. In addition, 2 years ago, in 2018, the government structures of Chinese governments is being reformed. In the case of intellectual property administration, the old SIPO, State Intellectual Property Office, was replaced by the new office together with the old Copyright Office. So both the old State Intellectual Property Office and the old Trademark Office were all replaced by one new administration, which is called National Intellectual Property Administration, CNIPA, National Intellectual Property Administration of China, which is responsible for handling patent and trademark issues and new forms of intellectual property, for instance, plant varieties, the rights of plant varieties, and a few other new forms of industrial properties. So the National Intellectual Property Administration is basically equivalent to the USPTO, United States Patent and Trademark Office. You see, it's a popular approach to structure administrative authorities in many countries by granting the administrative power to one specific authority for the administration of industrial property, patent, trademark, and other industrial properties. But copyrights, as a form of literary property, is in charge by another separate line of government agencies. In China, that's called National Copyright Administration. In the US, it's called Copyright Office of the United States. So that's a practices in China today and the US. However, in many other countries, they may have another approach. For instance, in the United Kingdom, now we have a new office called Intellectual Property Office. The Intellectual Property Office of the UK is in charge of any IP issues, including patents, trademark, and copyrights. So they have any IP-related issues being put in the hand of one government agency. However, the scenario taken by China and the US is a little bit different. Therefore, in China, if you are going to apply for trademark registration or patents application, you would have to go up to the National Intellectual Property Administration of China. The National IP Administration also in charge of proposing new legislations relating to trademark patents, to make regulations, administrative regulations, and to protect patents and trademark, and to enforce patent and trademark law as well. Section 2, Patentable Subject Matter. What are the things patentable under patent law?